So just to put it out there, reductions, and we mentioned this once or twice before, is when you are service connected for disability and you have a rating, and then the VA comes in and says, well, we think your rating is inaccurate and it should be reduced to a lower rating. So you would get what's called you should get what's called a proposed decision, okay, where they say that and they say, this is why, we sent you to an exam or we reviewed your medical records. They must give you due process of 60 days to respond with evidence, and they have to offer you a hearing to do this. And then if they go through all that and they still believe that you should be reduced, they publish a final decision saying you will be reduced as of this date. So Carol's got some thoughts on this whole process.
Well, my thoughts are they have to do that if that means you get less money each month. So say you were at 70%, and now they're going to reduce you to 30%. And you would get less money every month. They have to give you that notice. They have to give you 60 days notice, and they have to give you the ability to submit additional evidence in your favor. Well, we find that especially years ago, they never did that. And here's the scenario I see over and over again. The veteran has to get out of the military, and the military gives him a 70% rating. As soon as he gets out, the VA reevaluates him and immediately drops him down to 10%. Often, the majority of the times, I do not see them giving the required notice under the statute. And that means that is void ab initio. That means that if you prove that, they have to go back and give you the 70% all the way back to when they reduced it. And we find that reductions are so often done incorrectly that I look at all reductions to see if it's there. I have one now from 1969 that I think the veteran should be given 100% all the way back. They did exactly the same thing. He'd been in the hospital almost a year. And so when he got out, they rated him at 100%. Then the VA, 2 months later, decided, oh, he's much better, and gave him 10%. They didn't give him his notice, they gave him nothing. So if you have a reduction in your case, and that reduction meant that you got less money, you may be sitting on a gold mine. So look at your file. This is a key. This is one of the things that you can do.
So basically, they need to look at your whole record of examinations. This can't be based on just the findings of one day that something happened, okay? And they need to see if reviewing that whole thing, they find that you are less disabled, and at that point, they can reduce you. But the exam has to be full, and it has to be complete. It has to be an accurate exam, or as Carol says, they have to reinstate your benefits from the day they took it away.
And do you know that number, the 3 point, what is it, 3 point? Because this is very important. You need to read what they need to do and make sure that they did it. And particularly, if you have 100%, it is very hard for them to reduce that unless they can show fraud or you actually have gone back to work and are doing great. I mean, so you have a lot of protections. The problem is the VA does not give them to you. They just make you think you once again have to prove this. So please, what was it, 3.3144 or 3.105E was one of them.
And then 3.3, so it's 38 CFR. Whenever we talk about regulations, it's always 38 CFR. And the 3.344 is stabilization of disability evaluations. And that's basically, should it be stable, the same evaluation, or should it go down? And they got to show that basically in the day-to-day, your day-to-day life, has there been a material change, meaning that you have gotten better, okay? And, if a VA exam says today you're better, there's no problem, well, that to me shows they didn't look at all your record and see what's going on, see your latest doctor visits, listen to you to see, hey, is this just a really good day, or, is this your new, what we call that state, and that you're better?
And so one exam is probably not going to do it. But the VA will go with that. It's the BVA who knows what the law is. And almost all of the time, they're going to find in your favor. You're probably not going to win at the regional office. Now, if it's a current reduction and you can put in additional evidence, yes, you can win. But I'm talking about these old ones where they reduced you in the past.
She's talking about Q claims.
Yeah.
And as we say in here all the time, we never really talk about Q claims because you can't win them. This is an area where you can win them. If they
Yeah.
illegally reduced you in the past, then you can go in and beat them for not. You can beat them for not having done it correctly. But if it's an ongoing one, I think Carol and I actually do agree on this, and that you can win that at the regional
Right.
office. And how we win it is what we tell people all the time. Okay, great, you got 100%. Your P&T, still go to your doctor's
Right.
appointments. Okay, and if you go to your doctor's appointments and then you go hand into the VA all these records showing that, hey, you're actually not better. If you write a statement talking about that, if you get a loved one to write a statement about that, a lot of times they'll look at that and say, we really don't want to mess with this anymore. We'll just leave it as it is, and go on with their lives and let you go on.
But letting everyone note there, if you've got a reduction years ago, that those are things we look at. So when people call in and talk about what they're looking for, those are things you should point out, whether you're coming to us or anybody else, because that we don't know what's in your file. But if it's something like that, that's something lawyers look at. That's something you can win.